And so people ask me when I lecture, say, Eustace, what do you do about your taxes? How do you handle paying taxes? I said, well, I pay anything I owe. But I've never heard from them that I owe anything. So I said, they never call. So I'm not hiding. I'm in the phone book, and but they never call. It's a little disappointing in a way. But I mention this simply to show you, after all, as I say, I'm not a lawyer. I have no legal training except what I've undergone myself. But appearing in court is the greatest legal training in the world. Because they're going to throw everything at you that they have, and you either win or lose. Mostly I've won. Like I say, I have my default judgments. They don't bother me anymore. And I do give legal consultations to other people. I tell people, call me anytime. People call me up and ask me about legal problems. And my friends say, well, you don't know who you're talking to. Those are probably agents. And I said, they probably are, but I don't care. And I give them the information, and they can do with it what they want. But like I say, civil procedure is so simple. You only have to do three things. You deny everything, and you answer everything. And as long as you do that, you stay in court. That's it. I just gave you a whole law course. But the last few years, I've done a lot of civil rights cases because I say I've been denied freedom of speech and the right to speak many times. And I had a friend named Bo Greitz who has a radio program, and he went up to Cape Cod, and he came back and he said, Eustace, there's a bunch of guys up there, and one of them owns a chain of restaurants. He said, I was up there and I was wined and dined, champagne, the works. He said, you ought to go up there. I said, well, it sounds very tempting. So I contacted these guys, and sure enough, they said, come on up and speak. So they put out flyers. They call themselves the Freedom Forum. And I was to speak at a Greek Orthodox church. The Greeks, of course, are very prosperous up there. They have restaurants and they have lots of money. And they built this enormous, beautiful church, which had a lecture room. So they put out the flyers. So then the newspaper attacked. Cape Cod Times did a front page story on me. Notorious conspirator is going to speak in Centerville, which is Centerville, Massachusetts, which is the next town from the Kennedy compound. And so they put pressure on the priest to deny me speaking there. And the priest said, I can't do it. It's a commitment. We've already agreed, and I have no grounds to stop it. So they got desperate, and they started calling him up and saying they were going to blow up the building if he allowed me to speak there. And, of course, under that pressure, he caved in, and he announced to the paper that I would not be speaking. So I sued the Cape Cod Times, and when I sued the Cape Cod Times, I realized that it was owned by Dow Jones, the Wall Street Journal. So I sued the Dow Jones Corporation in Virginia. There was a Dow Jones Corporation in Virginia. Well, we went before a federal judge in Virginia, and he said, Mr. Mullins, I have no jurisdiction over this. This is a newspaper in Massachusetts. And so what do you want me to do? And I said, well, I'll sue under jurisdiction. So he moved the case up to Massachusetts. And so my suit against Dow Jones Corporation went right to Massachusetts, Barnstable, Massachusetts. And so they had no intention of ever hearing the case. So they finally dismissed it. And so then I reopened it, because you can always reopen a case. I reopened a case recently that had been summary judgment against me a couple of years ago. And I reopened it on the grounds that I was ill at the time of the judgment and could not respond, could not appeal, which was absolutely true. So I got that going now. And of course, that's the last thing they ever expected, is me to reopen that case. And the judge hasn't answered. Of course, the other lawyers answered, and they're very indignant. This is illegal, and you can't do this, and all this nonsense, which lawyers' responses to pleadings are absolutely primitive. They usually have no logic, and it's just like a fit of temper. Darn it, I'm not going to let you do that. That's the whole idea, you know. And so they're so incompetent when it comes to matters of law. They seem to have no respect for law, but of course, being Freemason Lodge, they don't have to have any logic to what they do. So I eventually had 3 civil rights cases dismissed in Massachusetts. So I sent due notice to the court, and I pointed out that I had had 3 civil rights cases dismissed in Massachusetts, denial of jury trial in each one. So I still got one going on because one case where they got summary judgment against me, I refiled against 3 other people who were involved. I knew the judge was going to rule against me in a few weeks. So I hastily wrote a complaint against 3 other defendants who were involved, who had not been mentioned in the original case, and drove up there and filed it with the court when it opened at 9 o'clock in the morning. And so after they filed a summary judgment against the Berkshire Eagle case, then I still had the case against these other people. And so then I amended that complaint. I developed cancer, by the way, and I amended my complaint to include the fact that they had caused me to have cancer by all the terrible stresses that they had subjected me to, and that cancer was caused by stress. Well, let's put the lawyers into orbit. They'd never heard an argument like this in their life. And that's still going on. And now the judge has taken it under advisement, which means he's absolutely terrified and doesn't know what to do. When a judge takes a case under advisement, it means you won't hear from him for at least a year or maybe 2 years. And so I just get busy with other things, you know. You don't sit around waiting for the judge to do something. You get to file some other suit. I got a couple of others. On July the 2nd, my hometown newspaper there in Stanton, Virginia, interviewed me. And they called and said, we want to interview you about Revelation Books. Revelation Books is an imprint under which I published The Curse of Canaan in 1985. It was totally inactive, and so they listed me as one of the leading hate groups in the United States, Revelation Books. So this girl called me up and said, I'd like to interview you about Revelation Books, and I was totally mystified. What was there to say about Revelation Books? Well, she brought in this report from an outfit called Southern Poverty Law Center, which claimed that I was one of the leading hate groups in the United States. That is, Revelation Books was, not Eustace Mullins. So I very patiently explained to her that this was all untrue, that there was no hate group, and there was no members, no newsletter, and it was a Christian publishing company, which was inactive. And so she went away, and I thought they would never print it because there was nothing to print. Well, they came out with a front page story and a lot of stuff from Southern Poverty Law Center that I had been lecturing before all of the leading hate groups in the United States, listing none of them because there weren't any. I mean, this is the only hate group I've been at lately. You'll probably be called a hate group after I've been here because but the guy that ran the Southern Poverty Law Center is a guy named Morris Deese, and he has been so successful, he has raised $500 million cash from suckers through promotions that he's going to fight hate. And, you know, fighting hate is not that hard. You just go out and fight it. And you might have to spend $500 million, but at least you're doing something worthwhile, you know. So I wrote an expose of him about 4 years ago, and what Morris Deese was doing was counterattacking me for writing this expose. Because, of course, he never answered anything in it. Because what I did, I found his court papers in his divorce. And in the court papers, his wives said that he had urged them to go out and have sex with everybody because he wanted to get rid of them so they wouldn't claim his $500 million. And then he also was caught in bed with a homosexual. He just wanted to try it, apparently. And this is all court documents that I'm quoting, see. So this was all published and circulated over the United States. And Morris Deese never answered, but he bided his time, and he was going to lay it on me, and he did with this article. So this is actually one of the most blatant attacks on me yet, that I lecture before recognized hate groups, that I have a hate group myself, and which is non-existent. So when I get back, of course, I'll be filing more lawsuits. I'm going to sue for $9 million and $9 million punitive. I always sue for punitive damages because, after all, you suffer a lot when they lay this stuff on you. And mental anguish and suffering is something that has to be atoned for. I have a lot of mental anguish. I may not look it, but... But what I have done is show up the legal system for the totally inconsistent and ridiculous charade that it is. And here the judges and lawyers have been bringing people in for years and stripping them of everything they had. And they also, by the way, for people like myself, they have a special punishment called attorney's fees. And I sued the city of Stanton once of this accident where the guy tried to kill me. They had two black women who came to be as prospective jurors, and the lawyers for the opposition immediately shot them down and got them out of there very quickly. And because black women tend to be very generous in judgments against insurance companies, and lawyers know this, so they hustled these two black ladies out, and they weren't on my jury. This was the jury where they said I backed into the car and smashed in the side of my car. So, after this case was over, I sued the city for discrimination for not allowing the black women on the jury, which, you know, was a very hot issue at that time. And so we went into federal court, and of course the judge was not very sympathetic at all. But I noticed that the attorney for the city kept jumping up and saying, Your Honor, attorney's fees, attorney's fees. And the judge would look at him, and the judge was no friend of mine, but he said, no, I'm not going to award attorney's fees against Mr. Mullins. And the guy would jump up a couple minutes later, attorney's fees, attorney's fees. And he'd say, no, I'm not going to award attorney's fees. So I got to thinking, why is the judge not going to award attorney's fees against me? Because he's no friend of mine. And I finally realized that when you represent yourself, that the other side cannot assess attorney's fees against you greater than your own fees, which in my case were none. So I've been using this ever since. So if they ever want to assess attorney's fees against you and you represent yourself, you realize they cannot do it, because apparently under procedure you cannot assess attorney's fees against a litigant which are greater than the other side's attorney's fees. And I've been writing on that ever since. You find out these things as you go along. That's why I say when you go into court you win, because you find out things you would never know otherwise. And I've been using that, and of course I'm using cancer and I'm using everything because you use what is there. But the lawyers get so frustrated with me because they called in my witness in this case in Massachusetts for a deposition, and I was a little worried about it because he's very naive and had no legal experience. I knew they would make mincemeat out of him. So I flew up there to be there when he was there, and after I got there I looked at the summons for the deposition, and it said Stephen May, who is the plaintiff's witness, is hereby summoned that the plaintiff hereby summons him to this deposition in the offices of the defendant's attorneys. So I looked at it and I said, well, that's kind of odd because I'm not holding this deposition. So when I got there, I asked the attorney. He started off asking questions, very hostile to my witness. And finally May said, Mr. Mullins wants to say something. Well, so I said, Mr. Pessolano, I think we're here under false pretenses. He said, what do you mean? I said, well, this says that I, the plaintiff, am holding this deposition. I have nothing to do with this. He said, let me see that. You know, like he'd never seen it. He had signed it. He had read it and approved it. He had two attorneys in his office signed it and approved it. He looked at it. He saw right away. He said, oh, clerical error. Well, go ahead. And I said, well, I beg your pardon. I said, we're here under false pretenses, and it would be illegal for us to proceed. And his face turned absolutely black with hatred of me. And he said, point well taken. And he closed down the deposition. So then they tried to summon May back again, but they got the wrong address, and the time expired, and they never did have the deposition. But that was the most humiliating experience that guy ever had, was for me to call him down. Now, you see, another lawyer would have been gracious and said, yes, clerical error, let's go ahead and proceed and just ignore it. But I said, no, it's illegal. It's false pretenses, which it was. The summons was totally false. Said I was having the deposition. I had nothing to do with it. So always be prepared to object, speak up, defend your own interests. And that's the way it's done. And that makes you a lawyer. You are now a practicing lawyer. You can go into any court in the United States and, as I say, deny everything and answer on time. The time limits are very important because the courts are absolutely ruthless towards people who represent themselves. If you're a day late, they'll throw you out. Now, if you're a lawyer, they'll give them a little grace. They say, well, okay, we'll give you a couple of days extra. But if you represent yourself and you miss the time limit, believe me, they will rule against you every time. Because after all, you're the enemy. They want to get you out of there any way they can. So I think I'm running a little out of toward the end, but I'd like to have a few questions from you. I know you've all had legal problems from time to time. And as George Gordon says, surviving in the courts not only is an absolute necessity, but it can also be a hell of a lot of fun.
I was taken to court by Revenue Canada, and my husband defended me, Bruce Steller. I agree with you. It was amazing the amount of incompetence. It was mind-boggling. It was very enjoyable. It was fun. As a matter of fact, when my husband was finished with the 20-year auditor, I felt so sorry for her. I went up and gave her a hug. I felt so sorry for that woman. But we had a mistrial because the judge took us in the back room with the prosecutor to tell the prosecutor how badly he was doing.
Oh, yeah.
And he used that to get an apprehension of bias.
Oh, yeah.
So I was wondering if you would sue the prosecutor for that.
Oh, you certainly could because it's improper, illegal activity on his part. He's liable for suit. See, any prosecutor or public official can be held responsible for their actions. There's nothing in any statute which says that anybody can act illegally. If they go beyond the bounds, they're just as liable as you or me or anybody else.
He got caught doing a few little things there during that trial.
Well, they usually bend the rules. They get so used to it and they do it,
Yeah.
and nobody ever says anything because they're afraid to do anything about it.
Yeah.
And they get used to getting away with it. They get very sloppy and very careless, and they leave themselves wide open.
Yeah, it almost seemed like a conspiracy to me.
Oh, it is conspiracy.
Yeah.
It's conspiratorial. After all, it's a Freemason lodge
Yeah.
operation.
And the Crown prosecutor seemed very worried about what we were going to do from that point on. He was
I'll bet, yeah.
trying to explain himself at the end of the trial. After the mistrial, he was trying to explain how his intentions were really honorable. He wasn't, we're looking at him going, we don't want to hear
They
this.
probably never had an honorable intention in his
Yeah.
life. But there's no statute of limitations on that. It comes under conspiracy. You can open that case anytime you like.
Yeah, I was thinking about that.
Statute.
What do you think, Bruce?
Yeah, one of my secrets is I use conspiracy all the time because, and it is a conspiracy, because that abrogates the statute of limitations. It doesn't matter how many years have gone by, you can always reopen this case, and it's just like a new case right then.
One of the legal issues that I've been wondering about is that I'm a dancer, and as a result, I sometimes frequent particular clubs. And a couple of the issues that come up, which I'm stuck at how to deal with, is one, people blowing smoke in my face, and secondly, music that's so loud that's causing permanent damage to the patrons. And so I'm wondering, is there a possibility of turning to the legal system or filing law? Could I be the first person to file a lawsuit for this type of thing, or how would you recommend I proceed?
Well, there's been a lot of suits in the state on secondhand smoke and also loud noise. So it's actionable on either count or both counts. I would sue on both counts, damage and suffering from eardrums and from secondhand smoke.
Secondly, when I went through my marriage separation, my first lawyer was probably the most popular lawyer to represent men in Vancouver, but extremely incompetent. And when I talked to my lawyer friend, when she found out that I had him as my lawyer, she said, get rid of him immediately. But that was a little bit too late. There was a lot of damage done. And I'm wondering whether it's might be still possible to file a lawsuit against him, and even actually a lawsuit against my spouse's lawyer for the damage that was done to my child, for example.
Yeah. Oh, very much so. As I pointed out, when you file a malpractice suit against a lawyer, it costs them a lot of money, so they don't like to let them lay around. They'll probably try to settle with you pretty quick because they don't like that against their record, that the suit has been filed, and also they have a good chance of losing, because lawyers lose suits against them in court because nobody likes them anyway, and they know they're incompetent, and that all the allegations are probably true. So lawyers have a very bad record for losing in court, so you've got a very good chance on that. And I must say, divorce law is one of the great gold mines of the legal profession, because once a couple decides to divorce, what they should do is have arbitration and come to an amicable agreement to divide up the property. Because when each side goes out and hires a lawyer, then it's the duty of those lawyers to stir up the wife and husband against each other, make them hate each other bitterly, and make sure that they're so mad they'll never get over it, and then they become putty in their hands, and they can start a war, and the result is that the lawyers wind up with all their property. They wind up with nothing, and they hate each other, and it's just a total disaster. But that's the way lawyers work. Lawyers also in the States have a great habit of, when a good-looking young woman walks in and she's going to divorce her husband, the lawyer realizes she's defenseless and alone, and usually takes her back in his office for a private consultation. And so things take their course from there. And lawyers are notorious for this. So they take advantage of women terribly. And this is one of the things that they do, one of the illegal and improper things they do. So their treatment of women is almost as bad as the medical profession.
I really enjoyed your talk. I've got a question for you. On civil law in Canada here, law of contract, now they're taking it to arbitration. Prior to that, they will put it to mediation, where they try and get you to agree between yourself.
Yeah, arbitration,
and, yeah. Yeah, and they do this before it goes to court. Now, what would be your comments on that, procedure-wise?
Well, the problem with arbitration or mediation is that you agree to be bound by the conclusion before it's heard. So you're committed once you go into it. I've never gone into arbitration myself because I prefer the court arena and a chance to show off my legal talents. So I would never do that, but it certainly can help, and it's a shortcut, and it could save you some time and money. It's just, it would depend entirely on the circumstances and the case itself.
Two quick questions for you, Eustace. Thanks very much. The first one, you made a statement during your discussion about the fact that a judge is obligated to give you legal advice. What is the basis of that? Is that
that's the official rules of the American Bar Association.
Okay.
Because, well, for many years, nobody ever represented themselves in court, so it wasn't an issue. And people started doing this in the last 25 years, and the American Bar Association had to address the situation. So they came up with the very logical conclusion that, yes, the judge is there as a referee of the parties. And as a referee of the parties, it's his obligation, if a litigant doesn't know what to do, that he should give him a little push in the right direction. But they refuse to do it, and the judges say we cannot give legal advice, which is a total lie. And I never got any help from a judge, which was probably a break for me, because I went out and did it myself, and that was worked out the best all the way around. But they are obligated. You can, well, of course you have the Canadian Bar Association. They probably have the same rules, but you could point out that the obligation is for him to help you.
Okay. That leads in perfectly to my next question, because you've talked about the American Bar Association and the Canadian Bar Association.
Yes.
And I would like you to confirm that indeed the word bar stands for British Accredited Regency. Is that correct?
Oh yes, this all comes out of England, and that's why I was talking about the London connection and the Bank of England, because Our CIA, our intelligence agency, was conceived right in London by Lord Mountbatten and 3 members of the British General Staff. Our Evangelical Association came out of British Secret Service in 1848, Lord Palmerston. So everything that we have is really secondhand. It comes through England first, and so what we should do is just have a queen and be done with it. You know?
Thanks so much.
Surely.
Thanks for coming, Houston. It's great to have you. I have a question for you. I've got the tyrants from Revenue Canada. They invited me to court, and they've got a lot of documents on me, and I don't think it's really, well, I know it's not in their jurisdiction to even have it in their possession. How would I turn that tide to be the plaintiff on that?
Have they filed charges against you? Are you a defendant, are you?
Yeah, for not filing.
For not filing, oh yeah. Well, there again, well, once you become a defendant, it's very hard to switch over and be a plaintiff, unless you go into another jurisdiction and file against them as a plaintiff, which you can do. You could actually, you say they're Canadian and you're what, U.S. or?
I'm a Canadian.
Well, you can file in your own jurisdiction against them, and it's amazing what a countersuit will do. It reverses everything. That would be my advice. Countersue them in your own jurisdiction, and they'll probably drop the whole thing.
Okay, thanks for your time.
Sure.
Hello, Eustace. I have one quick comment and then a question to leave you with. 1990 Thompson decision in Canada's federal court system, Superior Court of Canada, was upheld in 1996, upheld in Ontario Court of Appeal 1990 ruling in the Thompson case. It's a matter involving a corporation. That criminal acts in Canada are not fundamentally illegal. There's only a penalty if you get caught.
Oh, yes.
But they're not prohibited.
Not prohibited. That's interesting.
And so that's something that I find quite interesting as well. So I wanted to share that with you. And also, David Wynne-Miller you referred to, or is it another David Miller?
David Wynne-Miller. Yeah,
Could you elaborate on your relationship with his personally or his procedures?
Oh, it's not personal. We write for the same papers, contact. But I found a lot of David Wynne-Miller's conclusions were very good, and some of his stuff I could use. But fundamentally, I found in dealing with internal revenue and dealing with the courts, it comes down to your individual decision as to how you're going to defend yourself and use the particular elements of your own situation to do it. Like as I say, I went after the FBI and RS for conspiracy to put me in a mental institution. And if you look at your situation, you can always find something you can use. Just examine it very closely and figure out what's going on and how you want to go about it.
So this question's on, it's a domestic issue. If a plaintiff enters an action against you, and as a defendant, you wind up getting orders in your favor, and subsequently the plaintiff decides to drop the action, does that nullify the orders that the defendant achieved?
Generally, yes. If the plaintiff drops the action, it's called a non-suit, then that voids the decisions usually. Because the decision was only